Abusua ya za tena si biem ne tena si na chese ye de ni ene ebo e de ra e yo my Ghana political stories na no so trending ni bi na chese ye so ya sesa ye nkuku ni nkaka so e de ba be di ho komo na e de ni e de kire ye story ni ma na chese ye de ni ebo e de ra e ye CID e yo ma kache am na o ka say e ye new set of e ye petition any evidence bi enso a storm wo e ye o ma kache a e fa e ye chama Wontümi cases a e ye Andra on also go jina court ano MI Bailey no na new charges and so arise against him no. Na kame akoye say Martin Kpebu ene nkofoko bi na che so mo so tena ase a se mo so nyamana asem a eye Chama Wontümi enso ekodiye ewo eye Ghana ye forest mu no omo so atena say research agada evidence actual petition e dey akoma CID say CID no enso enye investigation na say eye the next courses no yenjeli eye Chama Wontümi ewo nyamara asema ono so ekodi ewo eye forest reserve ni abuzu me say better ne abo e dey rasa issue medase
na no co-chair of the Citizens Movement Against Corruption and Kwame Esedu Fellow at the Center for Democratic Development, that's CID Ghana. So these were the 4 persons who petitioned the CID in 2022 for the CID to look into the operations of Akonta mining and also to look into the conduct of Chairman Wontümi himself.
See, let's backtrack a bit. And thank you so much, Kpebu, for joining us here on Ghana Tonight. You just saw your face there. But then again, let's start off with the concern raised by Chairman Wontümi's lead counsel and the appeal could be that this bill sum of 25 million in his view is frustrating, and that as he's saying now, the bail conditions are being used as some form of punishment for accused persons. You are passionate about bail. Your contribution to jurisprudence in the matters of bail is clear and documented. Will this concern find favor in your sight?
On this particular one, I'm not able to stick out my neck to say it is excessive or not because I don't have the full facts. When I mentioned I don't have the full facts, what I'm looking at here is the cost of reclaiming the land. You see, he is alleged to have committed galamsey, right? And we all know from even some of the complaints that we even laid earlier. You know, we even sent a petition to the CID earlier in 2022, etc. What you are looking at is the distraction to the forest, distraction to the environment. How much would it cost to reclaim? So in a case like this, it will be fair to look at that. And so that would influence the amount of bail being set or to be set. So because I don't know how much it will cost to reclaim the land, it's not easy for me to say this is harsh or this is lenient. Yes.
I see.
Because let's give an analogy. You see, so let's say if 100 million Ghana cedis was lost, stolen, etc. Normally you hear the judge say, okay, post bail in the sum of 100 million cedis, because if the facts show clearly, I'm not saying every mention of any amount, then the judge will put the same amount as bail. No, you look at the facts. If you can show that 100 million cedis left one person's hands and entered another person's hands, and they have since not left that second person who is being accused in court, yes, it would start to reason that the judge can say, okay, post 100 million cedis bail. But let's say if that same 100 million cedis were to come into the hands of the accused, and then the evidence shows that, the accused used part of the 100 million cedis to buy land, houses, cars, and then the facts of the case show that, they have impounded, the police have impounded, of course, then there are issues of go for freezing. So for now, I'm just using the word impounded loosely. But what I'm saying is that if the facts show that, they've taken charge of the houses, the land, etc., and you can see, even if they don't put values by each one, but let's say if they say out of the 100 million cedis, we saw that 100 million is not even up to $10 million. Yeah. But let's just round it up. So if they say, we got, let's say, 5 plots of land in East Legon, maybe Range Rover worth 200,000, Land Cruiser worth $150,000, or even if they don't say $150,000, but they say 2024 model of a Land Cruiser, Range Rover 2023. You see, as soon as they mention a number of things, even without an official valuation, we all have an idea that, oh, a fresh Land Cruiser would cost this, a fresh, you know. So in such a case, a judge may put the bail at, let's say, 20 million Ghana cedis, even though he's alleged to have stolen 100, because in that case, you see that a lot of property has been impounded or frozen. And when I say frozen, sometimes there's no official order yet, but at least what the police are saying is that they have taken over. And I'm saying in such a case, the figure will come down. So it's always about the facts. That's why I said for me, in this Wontümi case, the critical thing I'll be looking at if I were a judge in setting the bill would be the cost of reclamation. Yes. So in that case, we would wait to get a fuller rendition of the facts to be able to make a determination whether we think that is harsh or unjust.
I see. But you listened to Dennis and he ran through all the charges that have been preferred against Chairman Wontümi. He denies all these accusations. He says he's not guilty. The burden of proof is heavier on the state or the Attorney General, for that matter, to prove this, is it not? And so, in the words of his lawyers, to the extent that bail cannot and should not be used as a form of punishment or be excessive, you are looking at it from the perspective of the alleged crimes. You juxtapose that against the amount that has been slapped. Will that suffice?
Yes. Yes, I'm looking at what is lost. Yes, it's standard that a judge in fixing bail will be looking at what has been lost. You see, so Wontümi's lawyer cannot just throw it in the air that it's excessive. What you are looking at is what's been damaged. What have we lost? What has been damaged? What have we lost? These are the things. Yes, as for not using bail as punishment, yes, that is law. You are looking at Section 96, subsection 5. No, actually 4. Maybe I can read it. It's law. I have it here. It says, a court shall not withhold or withdraw bail merely as a punishment. Merely as a punishment. Yes, that is the law. But as I've mentioned, in this case, let's look at the facts. If you are looking at the a license from one company to the other without authorization, all those things, the most tangible one is the distractions. You see, the actual harm in the forest. Those are the ones that you can use to quantify. The other ones are smaller. They are generally minimal, of course. You see, so let's get all the full facts. But let's also remember that when Wontümi went to Iyoko, I think the bail sum was bigger than this. He satisfied it. Yes, let's check the record. At least the last time we knew, in Iyoko, the bail sum was not less than 100 million. Yeah, it wasn't less than. You remember that's the one, even the political, the candidates in his party were, falling over themselves to try to help him meet the bail conditions so that they can use that as part of their campaign message to the delegates. But I know that figure was bigger than this, it would appear. Yes, but he met it. So it means that this one is a matter of time. But let me quickly add that, you see, as we talk about this bail, trying to meet the bail conditions, one part we need to modernize ASAP is the searches. If you're bringing land, you see that when you go to Lands Commissioner, you want to conduct a search, it's not easy to get a search within a day or two unless you end up paying bribe. The system has not been fixed to give you a search within 2 days if you don't pay anything to induce the system. It's terrible. So I like mentioning it in court to judges that the moment we mention justification, then it means that we are just generally entrenching corruption in the public sector. Ask any lawyer, standard, you are going to conduct a search you need it quickly for the accused person to come. If you pay just the official fee, forget it. The accused will rot in the custody for more than a month and you will not be done. So in our bid to get the accused person out quickly, you have to, do something over and above the official fee. So much so that it becomes standard that, look, the official fee alone to the Lands Commission will not get you anywhere. We can't build a system like that. So please, we're begging the authorities to look at how to modernize the system for conducting searches at the Lands Commission and other government agencies so that it can weed out this rent-seeking corruption that we are entrenching.
And it's a progressive recommendation. I appreciate you. Thank you. Martin Kpebu, private legal practitioner. Let's stay a bit further on this. Dennis did reference the petitions which form the second part or the facts of the second case that was brought against Chairman Wontümi in the Criminal Court 1, as we got to know today. These were the petitions that were sent to the CID.
So like POG Media, I'm sure so be like now so subscribe to your POG political media as well. Any day no work on so I drop a subscription. Now I say enough for so as so it's me a POG Media any be no who the echo any day urban na my Ghana your political stories in him. Measure so say one subscribe and I say your first time obejebre na subscribe here my POG say the be answer be kan daily updates na you know so the ba platform so na come akwa say Wontümi dey enye say obenya ne 3 de dim sa e wo ekwan a ono to nam akunta mining license so edibo edibra eye Ghana forest reserves ni edikoyi former gudia na chese gudia no kra wo ye no my Ghana a said that nya ho faso bia na mum how ene eye o say ye na chese ono so dibre asase no ene ye forest na ono so bu nuane ade gu former for no kwa ne personal gain santi na eye court enso etwentwen nsem said e be ya wo benya the right judgment ade ama eye Wontümi.
As far back as 2022, about some allegations of this Akroma mining being involved in illegal mining in the Wontümi forest and other areas. One of the petitioners, Martin Kpebu is one of them, but another petitioner is joining us, Edem Senanu, is a co-chair of the Citizens Movement Against Corruption. Senanu, thank you very much. And getting to know that today that the petition you sent in 2022 formed part of the facts for one of the cases brought against Chairman Wontümi earlier today, plus the fact that the Attorney General did indicate the missing docket on this case had been retrieved and returned to him. Does all of this inspire any confidence?
The initial petition, I remember, was in 2022, and it was on the Wontümi Forest Reserve, if I am right. We do not appear to have had traction on that case. And so this is a new case. I hear it's based on the forest in Samre Boy. And whilst it is useful to know that the state has moved to get to court, and I hear he's been put on bail, chairman together with others. The question in my mind is what became of the initial case? Because in that instance, we had both the minister indicating that there had been no license issued for them. And then I think the Minerals Commission also confirmed same. So two very critical aspects of the state machinery publicly indicated that they had acted without authority. And so in order to prevent that kind of impunity, that's why some of us made the effort on behalf of the good people of this country to lodge a petition. And we've heard nothing since then, apart from the fact that they're going to investigate. And at some point I'd heard that it appears that the investigation docket or something had gone missing. So I cannot say there is satisfaction. In my mind, what happened to the initial case? And if a case can just disappear off the radar, it's difficult to have confidence in other cases. It is good that there's some other case, it is being pursued, but what happened to the earlier case? So
but to the extent that, and I was asked to the extent that the initial case you talk about, the Attorney General gave some evidence or some update to the fact that the docket to that initial case had been retrieved and submitted to him. And in fact, some of the issues that you captured in your petition formed the basis for the second case that was brought against Akonta Mining today. That's what happened today. So it's not as though what you sent in 2022 has been discounted. It's an integral part of at least one of the cases that we saw today. The second case specifically.
Well, if indeed, and in fact, it is that both the initial case, the petition we raised, together with engineer Dr. Ashbe and Martin Kpebu and others, is part of this case for which he's on bail, then yes, it would inspire some confidence that certain things are not just, falling through the cracks, dropping off the radar, and we are proceeding to others. In which case, then the subsequent case I'm hearing of Samurai Boy makes sense that we've not just ignored an initial incident and are proceeding to a new one. So that definitely will make me more confident that, as they say, the wheels of justice grind slowly, but grind they do. And eventually they catch up with persons who, infringe the laws of the land.
Well, thank you very much, Mr. Thank you. Appreciate you for this. And indeed, he's one of 4 persons who petitioned the CID as far back in 2022 on the activities, they say, of Akonta Mining and the forest reserve, specifically the Tano-Ndemiri Forest Reserve. Thank you for joining us here on Ghana Tonight. He is the co-chair of the Citizens Movement Against Corruption. You also had Martin Kpebu earlier. Let's stay a bit further on illegal mining, shall we? Because earlier in the day, in fact, we got this information right from yesterday flowing into today, the National Anti-Illegal Mining that was slapped on his client, who has not been able to meet it, reason why he's spending the night in police custody today. This is Andy Apiakobi earlier today. Take a look.
They are alleged to have committed and also making it difficult for them to be able to discharge their responsibility to secure the bail. It's a national issue that we need to discuss and not accept. It's becoming too many that accused persons are being subjected to a difficulty of finding value for properties that will secure their bail. It is a national issue that we need to discuss. I'm not sure that there is anything untoward, but there is a process that we need to accept and make sure that it serves the purpose for which the law was made. And in many cases,
so he also did indicate the position of the lawyers, of Bernard Chibuesiako, about this 25 million cedis bail condition, and the fact that he is certain that they will meet this condition by tomorrow, all things being equal. Take a look.
We've been able to secure bail for Wontümi and his company and the other accused person. They have been admitted to bail on various sums and justification. We are working on executing the bail conditions. We are currently working with the registrar of the court. Unfortunately, at this time, we are not able to secure the release of the accused persons for reason that the police will have to go and inspect their houses, the sureties, the houses of the sureties, and come back and give a report before the registrar could execute the bail bonds. So for now, bail granted in both cases. What I have to explain is that there is one case pending before Court 4, Criminal Court 4, and another pending before Criminal Court 1. We secured the bail and its associated conditions in the morning, only be slapped with another case that we needed to go to Court 1 to prosecute it. So the charge sheet as given to us was around 2 o'clock. So the court has just finished the second one and also granted bail.
So it's instructive to place the point of analysis here that Andy Apiakubi, the lead counsel for Chairman Wontümi, stated something that Dennis Babari-Wadam Esquire is going to get into, and we'll get on that path shortly. There are two cases today. There was a case at the Criminal Court 4, and then also another case at the Criminal Court 1. So initially, they had met the bail conditions for the case in the Criminal Court 4, that's 50 million. And then later, when the Sansa, another 10 million was slapped on him. That's the total of what we're seeing right now. And let's get a bit more into this. The full details of these two cases and the charges that are contained in these two cases that were heard in the Criminal Court 4 and the Criminal Court 1 earlier today. Dennis Babari-Wadam Esquire is with me. It's good to have you, as always.
Always a pleasure, Alfred, being here.
You're an officer of the court, so I know earlier today.
And that's it. So, coming on name, but Edward Media, it's a POG Media, the Abana Ghana authentic political headlines, a POG personal, Sabeti Miakano, now who the echo. And the air bandina or my Ghana political space. And I'm sure there's also subscribing to POG Media and the equal so job subscription. Now, share off for so answer a cabin who the echo and the air banner. Don't forget to bet me and so I slide it to the comment section. On wait me, I can say man as well. Didn't come on the Afaj Media, you say the Bayaj Media, and so a bay interactive. But that's it. So, J. Bray, I'll POG.